The Irish Government has recently published the Screening of Third Country Transactions Bill 2022, which will introduce a new screening regime for foreign direct investments in Ireland by parties established in third countries. Under the bill, there will be a mandatory obligation on parties to notify transactions involving third country undertakings to the Minister for Enterprise, Trade and Employment for prior approval. A third country undertaking is defined as a country other than Ireland, an EU or EEA member state, or Switzerland. This means that, for example, investors from the UK will potentially be caught by the bill if all other thresholds are met. In terms of the test, the Minister will decide if a transaction affects or would be likely to affect the security or public order of Ireland. The legislation will apply to transactions in a range of sectors, including critical infrastructure, critical technologies, supply of critical inputs, access to sensitive information, and the media sector. Transactions which fall within the bill include any acquisition agreement or other economic activity relating to a change of control in an asset in Ireland, or the acquisition of all or part of an interest in an undertaking in Ireland. Transactions will be notifiable if they meet certain thresholds, namely, first, a third country undertaking is a party to the transaction. Secondly, the transaction has a value of at least €2 million. Third, the transaction relates to or impacts on one of the specified sectors. And fourth, either the transaction relates to an asset or undertaking in Ireland, or for transactions involving the acquisition of shares or voting rights, the percentage of shares or voting rights changes from 25% or less to more than 25%, or from 50% or less to more than 50%. A notifiable transaction cannot be put into effect unless and until approved by the Minister. It is an offence under the bill to not notify a notifiable transaction, or to complete or further the transaction before approval. In terms of timing, the Minister has up to 90 days to issue a decision from notification, which can be extended up to 135 days. The Minister also has power to review transactions which are not subject to a mandatory notification. Under the bill, the Minister can review non-notified transactions completed within the last 5 years, or in the case of non-notifiable transactions, the Minister can review a transaction up to 15 months after completion. The Minister also has an ability to retrospectively review transactions completed up to 15 months before the legislation comes into operation. In terms of decision-making, the Minister has the power to authorise a transaction, to impose conditions, or to prohibit the transaction. The Minister's decision can be appealed, and there is a specific process for adjudication of appeals under the bill. Penalties for breach of an obligation under the legislation include fines of up to €4 million and up to 5 years imprisonment. We expect that the bill will have an impact on the timetable for completion of transactions in Ireland involving third country undertakings. The bill is priority legislation for the Irish Government, so it is anticipated that the bill will be enacted within the coming months and without significant amendment. We will be monitoring ongoing developments with the bill and would recommend that any businesses investing in Ireland would keep the bill on their radar.